Good afternoon. Thank you. There are about 3 members present up to now. We'll wait for a few minutes and let's continue our class. In the meantime, we are dealing with the third semester, second sem, third unit part. Today we'll discuss about the impossibility of performance of a contract. To understand, there is a small video lecture on this impossibility of performance of a contract. Please view this lecture and I'll be forwarding this to you also, link and all this lecture also to you. And also we will have an explanation, and this is a very, very important question. And I'll be forwarding the notes of this question also to you to enable you to write the exam. At the same time, you see that after completion of this class, you note down the notes in a separate notebook and see that it's convenient for you to carry for the examination and carry with you and learn this. All the questions which I sent earlier are also to be copied in your notebook and then to be studied. Don't do that straight from your cell phone or from your system, because that is very, very inconvenient studying from the cell phone or system. Once you note down, it's almost equivalent to 21 to 30 times of reading. So once you please see that, comfortably position yourself and write down the material which is being sent to you. Now I'm sharing this video. You listen to this video and then we'll comment on that after immediately after our class. If any disturbance is there, please inform.
Now, what happens when a contract is made such that the performance is impossible? That is, one of the parties or both cannot perform the contract because the performance which is contracted is of the nature, which is impossible to perform, which cannot be performed, which is humanly impossible to perform. What happens in such one? We've discussed a lot of contracts when we were studying about the nature of contracts. There we studied the impossibility of performance. We said, contract to, dig up a treasure for, let's say, rupees 1 lakh. It's impossible. You cannot dig up a treasure from the earth's crust. Or a contract to walk up to moon is again humanly impossible. You cannot walk up to moon. Or a contract wherein you change a person into a mouse or a frog. Such contracts do not have any place in law. But the impossibility may not always be existing at the time of the contract. It may occur after the contract has been made. We'll discuss about, because this is very important. We'll discuss about this point in detail. What happens when the impossibility exists at the time of the contract? That is, both the parties know about it and the condition of impossibility is existing at the time of the contract. And what happens if there is no such impossibility existing at the time of the contract, however, later on the impossibility creeps in? So these are the two cases that we'll study. So let us get started. We all know that all impossible contracts are void because they cannot be performed. They'll anyway be breached. The parties will not be able to perform it, and because of this reason, because the law says it is not the party's fault, it is impossible to perform, so it is nobody's fault, such a contract should be impossible. So impossibility of a contract leads to it being void. We know that. This is also called as frustration of the contract. When the performance of a contract becomes impossible, it is said that the contract has been frustrated. It is called as the frustration of contract, and such a contract becomes void. Now let us look at the first possibility, first case, wherein the impossibility is existing at the time of the contract. What happens then? If the impossibility is known to both the parties, the contract becomes void. Both the parties know that the contract is impossibility. Now, to explain these uh, points, I'll take an example. Let's say you come to my shop. I trade in cotton. So you come to my shop to purchase cotton from me. You give me an order of 100 bales of cotton. Okay. So I tell you, no worries, I have 100 bales of cotton lying in my godown. Now suddenly there's a fire that has come up in my godown, and all the cotton that was there is now destroyed. It's not there now because the fire has destroyed it. I get the news on phone, you are before there. So you hear me talking that there's a fire in the godown. And we still go ahead with the contract. I mean, does it make any sense? You know that there is a fire in my godown. I know that there's a fire in my godown. You know that I won't be able to supply you the cotton because it is impossible for me to supply cotton as all the cotton has been destroyed. Because the contract was about the cotton which is lying in my godown. Now there's no cotton currently or presently in my godown. Everything has been destroyed. So can I supply you that cotton which is not there? I cannot supply you. I know that, you also know that, yet we are going ahead with the contract. So tomorrow, you know that I'll not supply you the cotton because it is destroyed. Can you bring up a case against me saying I have breached the contract? No, you can't, because my contention will be you were there before me, you knew about the news that a fire has broke in my godown. All the cotton has been destroyed. So you knew about this news. At the same time, you also knew that since all the cotton has been destroyed, I'll possibly not be able to supply you the cotton. So this fact is known to both the parties, yet they are making the contract, which is for sure going to get breached. So who should be responsible for it? It is the mistake of both the parties. They knew about this, yet they went ahead with the contract. So such a contract becomes naturally void because you cannot blame the other party here. Both are at fault. So such a contract becomes void. What if this fact is not known to either party? None of the parties knows about this fact. We enter into the contract. You give me an offer to supply you 100 bales of cotton. I accept it. But there's a fire that has occurred in my godown. I do not know about that fact. You do not know about that fact. So, since we are ignorant about this fact, we go ahead with the contract. We make this contract because I find no reason which should hinder me from supplying you 100 bales of cotton because I have 500 bales of cotton in my godown. You see no reason why as to you see no reason as to why this contract shouldn't be made because you've already contracted with someone else to supply the cotton, and possibly I am the biggest supplier here, so you come to me for the cotton. Now because we are ignorant about the fact,
I hope all of you could able to follow this class. So once there are 5 in number now, very good. So all of you see that You listen, this is a very simple English and this is what been told of. దీనికి తెలుగు నోట్స్ కూడా నేను ఫార్వర్డ్ చేస్తాను. తెలుగు కూడా మీకు బుక్స్ ఉన్నాయి కాబట్టి ఇంగ్లీష్లో తెలుగులో కూడా మీరు ఫాలో అవ్వచ్చు. సో ప్లీజ్ లిసన్ టు ద క్లాస్. లింక్ కూడా ఫార్వర్డ్ చేస్తాను. తర్వాత కూడా లీజర్గా ఒకసారి మళ్ళీ రిపీటెడ్గా వినండి. విల్ బి వెరీ కంఫర్టబుల్లీ learning this. This is a very, very important question, impossibility of performance of a contract, and which also carries wonderful mark. And third unit lo ee question definitely meeku వచ్చే ఛాన్స్ ఉంది కాబట్టి రిపీటెడ్గా ఐఎమ్ ఇన్సిస్టింగ్ on you to follow this question and read and learn on this question.
We do not know that there is an impossibility which has occurred. Now, because of that thing, I'll not be able to perform the contract. So now both the parties are ignorant, they do not know. What do we do about this case now? Who should be blamed? Again, we cannot blame any of the parties because it is the ignorance of both the parties, and this contract will be void because of mutual mistake. It's a bilateral mistake. It's a mistake of both the parties. Both are ignorant, or they do not know about the fact that the fire has already occurred in the godown. So again, none of the parties can blame the other. So this contract is again void because of bilateral mistake. What if only the promiser knew? Let's say I knew that there's a fire in my godown. You didn't know. Yet I am going ahead with the. Now obviously you do not know, so you'll have no problems contracting with me. But I know here that there is a fire at my godown. Yet I am making a contract with you that I'll supply you cotton, which is lying in my godown. Now currently there's no cotton that is lying in my godown. All the cotton has been destroyed. I know this fact. You do not know this fact. So we make a contract. I induce you to enter into the contract. And as always, I breach the contract because I'm not able to perform the contract. So who is at fault in this case? I am at fault or you are at fault? You cannot be at fault because you do not know about the fact that there's a fire in the godown. I know this fact. Yet I am making the contract. So it is my fault. I am at fault. So this thing established that there is a fire in my godown, the cotton has been destroyed. So I cannot perform the contract. So this thing established. So now I cannot perform the contract. The court cannot enforce specific performance on me. The court cannot say, no, you'll have to perform. Because I'll say, Lord, my Lord, this is impossible. So now the only remedy that you are left with is the compensation. Whatever loss that has occurred to you, whatever investment that you had made, whatever orders that you have lost, you can recover it from me. Whatever loss in short that has occurred to you, I will be liable to compensate. So I'll just tell you two things. First is either both parties know about the impossibility or both parties do not know about the impossibility. In both the cases, the contract is void and none of the parties can claim compensation. However, when one party knows about the fact and it is still going ahead with the contract, then that party will be made liable. The only point here, remember, is that party should be the promisee, and that party should be the party which has breached the contract, which is affected by the impossibility. Okay. Now we come to the point supervening impossibility. Some call it supervening, some call it supervening. I mean, that depends on you.
favorite history
So,
between
what is
number
supervening impossibility?
favorite
Now, this
history.
word supervening means something which overrides, something which controls,
అది కొడితే వాళ్ళందరూ
something
వచ్చేస్తారు అన్ని
which
set చేసి.
is in such a position that it can change and control. So now what happens is the existing situation is controlled by some impossibility. This impossibility changes the existing situation such that the contract cannot be performed. Impossibility is crept. It has crept into the contract. But the important thing here is, here the impossibility was existing, and here the impossibility is supervening. That is, after making contract. In the first case, impossibility was existing at the time of the contract. And in the second case, the impossibility has come up after the contract has been made. So now let's see what happens if impossibility crops in after the contract has been made. The contract becomes void. So in most of the cases wherein there is impossibility in the contract becomes void. Now, I know that if there is impossibility which has come up after the contract has been made, the contract becomes void. But can you give me examples wherein the impossibility creeps in, impossibility crops up, it comes into the contract after the contract has been made? Yes. Any examples? I'll tell you. First, I've already given you the destruction of subject matter. That is, you come to me for purchasing cotton. I tell you, I'll supply you the cotton which is lying in my godown. You are okay with it. I am okay with it. The contract is on. And when I was to deliver the cotton, just a day before that, fire broke in my godown. So the subject matter got destroyed. How do I perform the contract now? How do I honor my promise? I cannot. So impossibility has crept in. Let's say we enter into a contract such that there's a ship which is coming from London to Bombay. Now you want goods from the cargo of the ship, and I am the person who's getting in the cargo. So I tell you, if the ship reaches the port of Bombay, I'll sell you the goods. And during the transit, during the shipment, the ship sinks, it drowns, or there's some hurricane or anything of that sort, such that the ship is destroyed, the cargo is destroyed.
So this is a
What
wonderful
now?
case study,
Impossibility
and he has given you a detailed study of what
I
all
cannot
things can
perform
be
the contract.
done with. So thank you very much for your